Hi, how are you all doing? Appreciate you joining me here. It's been since, man, losing my voice already. Hopefully this connection is holding up. I have two internet connections, and the main one that we have is affected by the weather. And of course, we've had crazy weather. So I have no idea if it's working. If it's not, please let me know. But again, appreciate you joining me. And it's been really since March of 2020 that just our state alone, West Virginia, has been ruled by one man, that's our governor, as a dictator under what's now known as a state of emergency form of government. And I fought much of the year last year to get our legislature into session, and others did as well, because our legislature could end that state of emergency just with a simple majority vote. And it became so important to those of us who really care about liberty and freedom to have a say in the process, because with our governor just using the emergency powers statute to act as a dictator, really he's got more power than the monarchy of England, because he has no parliament to answer to. He really has nobody to answer to. And so he just got to do what he wanted from, let's see, March, April, May, June, July, August, September, and so on. And so finally here last week, the West Virginia legislature meets. And I had been told all along, just wait, quit suing, quit going to the courts. Not that they were going to do anything anyways, but let the legislature fix this problem. Because the legislature had initially enacted this statute that allows the governor just to say, all right, it's a state of emergency, and to do that indefinitely. And if the legislature's not in session, they can't call themselves back into session in our state and many other states without a supermajority vote. Otherwise, the governor just gets to do what he wants. And if the courts don't stop him, the courts don't stop him. So finally, the legislature comes into session here, and they presented a bill to limit the governor's emergency powers. And as I figured, really what they were going to do is put a time limitation on it of 30 days or 45 days or 60 days. So a governor or the governor can only enact this state of emergency or declare this state of emergency rather through an executive order, and can only go on so long. If it's going to continue, the legislature has to call the legislature into session, and they have to be involved in the process, which of course makes sense. And the bill that apparently they introduced into the Judiciary Committee basically did that. But apparently something had happened today, and somebody sent me a link, and I appreciate that. And I was working so much today that I didn't follow what was going on, but the Judiciary Committee met, and the Judiciary Committee is just basically a committee of the legislature, and they debate and pass or amend or not pass a bill before sending it out to the full House. And this is the House of Delegates. And one of the members of the judiciary, who I believe had been fighting against to restrict these emergency orders for much of this time, put an amendment on that bill that said, oh yeah, this also applies to the COVID-19 pandemic that is going on right now. Apparently that must have really pissed somebody off, because that got taken out. Apparently somebody at the governor's office was upset about that. So what's the point of clarifying and restricting the emergency powers statute if it's not going to apply to COVID-19, if it's not going to apply now? I mean, we've only been living under a state of emergency now for, since March of last year. I mean, 11 months going on 12 months. Why can't it apply now? Why doesn't the legislature want to be part of running state government, of making the decisions about whether or not we want to have a mask mandate, of which we don't, why can't Obviously, our governor's not going to do it. Why can't our legislators, and we have a supposed Republican supermajority in the legislature in both houses, why don't they want to make us more like Florida? We only have 1.8 million people in West Virginia, whereas Florida has like 28 million people, and a large percentage of elderly people, including my grandmother, who is in her 90s and lives in Florida. Florida has no mask mandate. Florida has no stay-at-home order. Like we still have a stay-at-home order here in West Virginia. Florida doesn't have the stay-at-home order. They don't have any restrictions imposed by their governor. They don't have a mask mandate. And yet they're doing great. People are wanting to go down to Florida now, and Biden's having to try to stop them via executive order. He's been talking about issuing some sort of prohibition on domestic travel. I'll get to that. That's the scariest thing I've heard Biden say. Just to stop people from going to Florida to be free. Or South Dakota, and they've had their governor's taken the position from the beginning that their citizens ought to be able to make their own decisions about whether or not they want to wear a mask, or they want to not go to a certain business, or not get their hair cut, and so on. But no, we were continuously, and still are, talked down to by our governor, talked to like children, treated like children. And this is from somebody who obviously can't even control his own calorie intake. And by the way, heart disease is the leading cause of death in West Virginia, mostly from people being fat and having a poor diet. And yet, of all the things that could be mandated on us, it's just COVID-19 mandates, such as the mask mandate, which, according to the numbers, doesn't appear to have done anything whatsoever. But yet our governor's treated us like children this entire time. And so now the Montana's also open. Of course, shouldn't West Virginia be in those list of states like South Dakota, Montana, West Virginia? I mean, we have one of the reddest states anywhere. Yet we have this governor who's really a Democrat, who's acted like he's acted like a Cuomo, just with better staff around him to guide him in at least a better direction than Cuomo. But why can't we have a Kristi Noem or even a Ron DeSantis? I mean, I know you get the government that you deserve, but we just deserve better in West Virginia. I mean, we have our problems, but we have a voting base that, I mean, they didn't vote for Democrats as dog catchers in this state in 2020. And it was because of Trump. Which brings me to another thing. This whole impeachment ordeal with no due process. I mean, I'll get to that. It was absolutely insane. Yet we have a senator, and Joe Manchin, who voted for it, despite the fact that over 70% of West Virginia voted for Donald Trump. Yet our senator voted to impeach Donald Trump, even after office. And then our other senator, supposed Republican Shelley Moore Capito, she votes against the impeachment, or not the impeachment, but the conviction. She votes against it and then issues a statement that says something to the effect of, I voted against it on constitutional or procedural ground. And since when do any of these people care about the Constitution? After we've just gone through a year of having tyranny shoved down our throats with no concern about the Constitution. When do they care about the Constitution? They don't. And she called something to the effect of Donald Trump disgraceful for what he did on January 6th. Disgraceful. So 70% of her state supported Donald Trump. What polling data is she using that tells her it's a good idea to vote not to convict, but to call Donald Trump disgraceful? Who in the Republican Party, certainly not her, right now is more influential among Republican voters than Donald Trump. Now, you might not know if you watch CNN or MSNBC. Of course not. But I can answer that question. Donald Trump, he didn't disappear, and that's why they wanted to impeach him, just so he couldn't run for office again. But he hasn't disappeared. Yet our one senator votes unconstitutionally, clearly, as well as against the evidence, to convict them, and our other feels the need to virtue signal, and I don't know who she's trying to please, but to call him, his actions disgraceful. And this video is not about that, but you can go back and read every word that Donald Trump said. And he didn't start an insurrection. He didn't encourage an insurrection. It's absolutely absurd. The fact that he used the word fight, but he also used the word peaceful. I mean, it's just ridiculous. How can you say that was disgraceful? Or maybe what she's referring to is the fact that he was making election fraud claims, that was disgraceful. Perhaps that's what she's talking about. Who in their right mind denies that there were votes that shouldn't have been counted? I mean, we all know that. We all know that. Even the United Nations knows that you can't have mail-in voting. And I had a video where I went over this, and I looked at the guidebook, the handbook that the United Nations, I don't know what you call them, but the people that they send into all these third world countries to teach them how to have fair and open elections. The guidebook, literally, you can look it up on their website, has all sorts of advice in it and cautions in it, all of which were violated in the United States elections in 2020. I mean, the fiction that you can't question the integrity or the vote of the 2020 election is absolutely insane. Of course there were problems with it. There's problems with it in a regular year. But there's no doubt all sorts of issues from the 2020 election, and they weren't all voter fraud claims. A lot of them were constitutional claims where election laws were changed through some means other than going through the state legislatures, which again brings us back to all the mandates through the COVID era. It all was done through executive order, and that's the new way America works. Especially on the federal level, all these executive orders that we're getting. But even in the reddest of the red state of West Virginia, we've been ruled via executive order for the past 11 months, going on 12. You can go on the West Virginia governor's website and take a look at all of his executive orders. Or you can go on the West Virginia Secretary of State's website, where they get actually filed. And take a look at all the executive orders that he's issued since March 23rd or whenever it was of last year. There's over 100 of them, I believe, at this point. There's got to be 500, 700, maybe 1,000 pages worth of executive orders that created all sorts of policy, all sorts of law, and did not go through a legislature. But here we finally get the legislature in session, and they're gonna really half-ass it. They're gonna say, all right, well, from now on, we're gonna put a 30-day or 60-day requirement in there where the governor can only do it for so long without us getting involved. But we're not going to apply it until the next pandemic. That's not what they said, but that's what they implied. If you look at the newspaper article on that, and I can share that here, I think. All right, so this is just the basic West Virginia Metro News website, and this just came out today. Committee passed amendment applying limits to current crisis and rescinded it today. The House Judiciary Committee. Now, I know several individuals on the House Judiciary Committee, and I've talked to several of them numerous times about the importance of restricting the governor's emergency powers. And this was supposed to be big on the Republican agenda, but this isn't a good sign. The Judiciary Committee pulled back a bill placing time constraints on the governor's emergency powers and voted to remove a newly inserted provision meant to clarify that the bill applies to the current COVID-19 emergency. Okay, well, why wouldn't? I mean, how long are we going to allow the governor to have a state of emergency government? Now, we have a legislature that's literally in session. They're sitting at their desks right now or all day today. What are they there for? We still have a mask mandate. Like, okay, a lot of the arguments put forth in court, in my cases, and like I was told by judges, that, well, this is a new novel situation, and this is an emergency situation. The legislature wasn't in session. The governor has to take emergency action and has to do this. Well, it's been 11 months later, and now we do have a legislature in session. So if we need a mask law, shouldn't they be debating a mask law and either enacting a mask law and putting their names on it, or not enacting a mask law? Isn't that what a legislature should do? But they're not doing it. What should they have done? With a simple majority vote of the legislature, they can call an end to the state of emergency declaration, which wasn't meant to, it was meant to be temporary, very temporary. It's being used to, it's just indefinite. It's indefinite. They should have, day one, minute one, called a vote, or at least held a vote. All right, who wants to stop the state of emergency and get back to business as usual? If we need a law, we're here, we can pass it. If we want a mask law, we can pass it. And maybe they probably would, because you see the pictures of them with the masks on. So why do we have a legislature, and what we're paying each of them? This is 2 months work. We're paying each of them $20,000 for that 2 months of work. Why do we have them? Let's just abolish the legislature, and let's just give the governor credit for all of it. But apparently this is the delegate who tried to insert that amendment. And you know, one of the few patriots apparently up there, and he is from Hancock County, and maybe he didn't put the amendment on there. Not sure who put it on there, but he's quoted as saying, is objecting to the amendment being withdrawn out of it, and allowing it to go forward with no mention of it being applicable right now. All right. So anyways, you can read it for yourself. And here, and isn't this funny for the Democrats? Here's Chad Lovejoy. He's a lawyer. He's a Democrat on the Judiciary Committee. And here he is arguing against the governor, really. And where's this quote? All right. The ranking Democrat on the committee, Chad Lovejoy, was among those arguing against removing the amendment. In a bipartisan manner, we passed that amendment. We were taking it to the floor together. Now it's being stripped away. Can't argue with numbers. And this is a great point. I believe this is what he said. If you're ever asked, did you have a chance to step up for the legislative branch and take some role in what's happening to the citizens? The answer is, if you don't agree to this amendment, is I had the chance and I said no. Absolutely. This entire time, they had the chance to call us a special session with a supermajority vote. Some of them tried. They couldn't do it. But now they're in session. And they could do something to take some role in this entire COVID pandemic. And they've chosen not to. They've chosen to just pass that off to the governor and let him do what he wants for as long as he wants. And it's just absolutely absurd. I mean, who are we to complain to? We've got no one to complain to. We can't complain to I guess we can complain to our legislators. What I was going to talk about is basic search warrant law, because there is a Supreme Court case that's coming up where they're seeking to change the basic law of search warrants, as far as when law enforcement can come in your house, search and seize inside your house without a warrant. There's only a couple exceptions right now, and they're trying to create another exception. So and this sort of ties in to the gun control argument that's really coming on right now. And it ties together in this way. So the basic Fourth Amendment law when it comes to your home is that your home is your castle. The home is the most protected place under the Bill of Rights, under the Fourth Amendment, is your home. And that would include, under Florida versus Jardines, the area immediately outside your home, such as your porch. So the basic rule is that any government official, primarily a police officer, entering your home is, for the purpose of searching and seizing inside. And that just means looking for something or grabbing something. I mean, it could be a lot of things. They have to have a warrant. And if they don't have a warrant, then by default, there's a presumption under the law that it's unconstitutional, that's a violation of the Fourth Amendment. And there's only a couple exceptions to that. So you have to have a warrant. If you didn't have a warrant, the burden's on you to prove why it wasn't unconstitutional or that you had a warrant. And if you can't do it, then it's unconstitutional. So that is the cornerstone of Fourth Amendment law, of the law of when the government can come into your house. There are a couple exceptions to that. Primarily, the biggest one is consent, but consent has to be voluntary. And there's a big body of case law about what kind of consent is voluntary, or in other words, if they put a gun to your head and say, do you consent to us entering your house? And if you say no, I'm going to shoot you. You can say yes, and technically they obtained consent, but was it voluntary? No, it wasn't voluntary. So therefore, there is no voluntary consent. That would not meet the exception. So that's consent. And for some reason, when the cops ask a lot of people, can I search your house or can I search your car? They say yes. Why? I don't know. And sometimes cops lie and say they said yes, but they didn't. That's why it's great to have body cams or record with smartphones. I mean, there's all sorts of ways to catch people lying about that. So probably the more ways that there are, the less it's attempted. So consent is a big exception. What's another big exception is exigent circumstances, sometimes called, an emergency exception, emergency aid. And that's basically like if the cops have information to believe that there's a domestic violence incident going on inside, that was the reason they were called. They hear screaming and banging. They don't have a warrant, but they can go in, and based on those circumstances, this crazy weather. I don't know, it's messing with our power. Hopefully this is still on. Or there's a baby choking inside, something like that. There's some sort of health emergency or violence going on, something that they're presented with at the scene, and they can articulate that. That is the emergency aid exception or exigent circumstances. And that's probably the biggest one, other than consent, that's used as far as warrantless entries or warrantless searches in somebody's house. Now, you're always less protected in your cars. Anytime outside the house, your car is like the least protected place that you can be. And you're in fact more highly protected as a bystander walking down the sidewalk than you are in your car. Ever since cars were invented, the police, with the help of the courts, were thinking of ways to restrict our rights in those cars, of new laws. So there's a huge body of law as far as the search and seizure surrounding a car. That's primarily following a traffic stop. Sometimes it's other scenarios, such as a search of a car where there's nobody there, it's just a car. There's searches of motorhomes, RVs, and trailers, and the law can be different in all sorts of scenarios. So one of the exceptions to the warrant requirements as far as a car they've come up with is something called the community caretaking doctrine. Community caretaking doctrine. And this is what gets us to what's going on now with the Supreme Court. So the community caretaking doctrine, that is basically just, well, I was doing what I thought was right for the community. And it means nothing really. It's kind of crazy. So it's sort of like saying, well, I'm using the exigent circumstances exception, but there's no evidence that it was an emergency. There was no emergency, nothing immediate. I mean, there was time to go and get a search warrant, but just based on, what we do as frontline heroes and first responders and all this, we were acting in good faith and doing a service to the community. I mean, it means pretty much that little. So this has been used outside the context of the home, like in cars, or I'm sure it's come up with situations with bystanders, maybe with backpacks. But now what they're trying to do is apply that to the home. And that's this case that's going up to the Supreme Court. Is basically the issue is whether even though the home is the castle, the home is this sanctuary of the Bill of Rights, of Fourth Amendment protections, can we allow this same exception that's been used outside the home to apply inside the home? And some of the federal circuits have gone different ways on this. Now, when I first saw that it was accepted to the Supreme Court, I thought maybe it was one of my cases, because I had a case out of West Virginia, out of the Eastern Panhandle, where that was exactly what the police claimed. And this was involving the state police. It's exactly what they claimed was the so-called community caretaking doctrine. Now, that was a civil lawsuit, not a criminal case. So it ended up with a grant of qualified immunity to the police officer. And that, I believe, is being appealed to the United States Supreme Court right now, because it was an incorrect decision on all levels. There should have been no qualified immunity because there was no warrant. And there is no community caretaking exception right now. Though that, I don't believe that's what they held. They just gave him qualified immunity because they didn't think there was any close case. I don't know. They didn't really explain it, but that's for another video. But that's what's going on right now, is whether the U.S. Supreme Court will extend that to the home, and hopefully it doesn't. So I have to keep a close eye on that. The other time I've had them try to use that against me is in the Michael Walker case. That's the open carry AR-15 case from Putnam County, West Virginia. Now, if you saw that video, it's on the YouTube channel, and it's been all over social media. If you've seen that video, you know that my client Michael was walking down the side of the road heading coyote hunting, and that's when he was encountered by police. And basically, it was a Karen call, and they came up and they started asking questions: "Where are you going?" and wanted to get his ID. And he said, "Well, what did I do wrong?" And he didn't want to participate in that. Didn't want to hand him over his ID, though he did. Didn't want to answer questions. And that's when they called him a you-know-what sucker 3 times, or at least the one cop did. So that had nothing to do with community caretaking. The defense after the fact, once we filed a lawsuit and defense lawyers became involved, were, well, there's a private school about a mile down the road. Theoretically, he could have been walking towards that school. This is right after the Parkland shooting. There could have been, there were generic concerns in the law enforcement community about so-called copycats. And therefore, there was reasonable suspicion to stop and get his ID and run a background check on him and question him, just by virtue of the fact that there's a school down the road and he had a scary black AR-15, and that is a weapon of war. And he also, I can't remember, there were a couple other really nonsensical reasons that they gave, but the legal theory that they rested on for those ridiculous claims was this community caretaker exception. So that there's this just vague duty of police officers to care for the community. And even if it doesn't meet constitutional requirements, they could stop you and get your ID just because they're in the process of just trying to help the community, which doesn't even mesh with the facts of that particular case. But remember, the way the courts judge all of these civil rights cases is all with an objective standard. Even if the particular police officer involved was acting in bad faith and knew and did not believe that there was a legal reason to do what he did and just wanted to harass the person or discriminate against the person or whatever, it doesn't matter to the courts because they use this objective, reasonable officer standard. Frozen balls. Cops drink diarrhea milkshakes. Appreciate the comment, Frozen. Save the humans. Thank you for not using the offensive word assault weapon. Well, I don't want to offend anybody with offensive words like that. In fact, in my brief in the Walker case, I went into, I don't remember if it was before the Fourth Circuit or in the briefing back before the trial court, but I tried to bring up, what AR stands for, the history of the AR-15 and the ownership numbers of the AR-15 and the fact that it's like the most popular hunting rifle, even when the judge was saying that they aren't used for hunting, they're just used for killing children and so on. I tried to bring that stuff up. Not that it was even in the record of the case. Didn't have anything to do with the case. But there's, the media has just soaked people's minds with all this nonsense about AR-15s. So I appreciate that comment. Arms are every weapon for offense and anything for defense. It's absolutely, none of it makes sense. I mean, I don't want to get into that because I'll be talking about that all night. But, if you look at there's that Ninth Circuit case, I think it was Duncan versus Becerra, involving, and maybe confusing them because there's a couple of them in the Ninth Circuit in California and Hawaii. But there is the magazine restriction case where the Ninth Circuit had found that there is a Second Amendment right to have high capacity magazines. And they went through the history and the opinion of, firearms technology. And I've gone through that before because you can go back to the Civil War era, and that's when the Henry repeating rifle first came out, and it had like 14 or more rounds in it, depending on the Henry was all 44 Henry caliber, but then the Winchesters, depending on their caliber, they had something like 14 rounds, something like that. And then into the early 1900s, then we had I don't know what's going on with my power. Then we had the, self-loading or semi-automatic rifles that, at that time, when they first came out, you could get them through the mail. And that was the history of the United States is wanting, firearms that could quickly repeat themselves, that could shoot as quickly as possible. It wasn't about hunting. It was about the ability to defend oneself. The ability to have, effective weapons for self-defense. Let's see. Have you seen the video regarding Waco, Texas cop who pulled a taser on the man not wearing a mask and legally, openly carrying a handgun? I'm not sure. I've seen a bunch of videos. I don't recall if I've seen that one in particular, but if you can, email me a link to it. It's jhb@johnbryanlaw.com. See, the Titusville, Florida area is a seller's market here because we don't use our votes for jokes. Socrates, just plain anti-American scum. Well, that is the county, Bo, where I grew up in. I wasn't born there, but I was raised in Brevard County, Florida. So I've been to Titusville many times. In fact, as you bring it up right now, I'm thinking about eating rock shrimp at Dixie Crossroads, probably my favorite restaurant in the world, right there in Titusville, Florida. And I've also been to the Kel-Tec factory there. I think that's maybe that's in Cocoa. I don't know. There's a lot. I mean, there's a lot of gun business around there. We got the Keltec factory, and there's a few others. Can't think of them off the top of my head. Well, Titusville is also where Reed Knight's museum is. So that's probably about 40 minutes north of where I grew up. So oral arguments in that case, the case I'm talking about, Walker versus Donahoe. It's coming up on March 8th at 2. No, I'm confusing cases here. I don't recall what time, but it's coming up. It's on the docket to be heard for oral arguments before the Fourth Circuit on March 8th at some time. I want to say 2 o'clock, but I think that was the last case I argued. So it's remote. And this will be my first time doing that remote. So I don't get to actually go to Richmond to argue this. I'm going to be sitting somewhere around here in my office. And so that's going to be kind of weird, but it will be live cast on the internet. So that's something you can watch. And why is that case important? Because if we lose that case, then we've had a string of bad decisions in the Fourth Circuit, and having to do with them refusing to find Maryland's assault weapon ban unconstitutional, and that was in, I think, 2017, U.S. versus Robinson. We've had several bad cases in the Fourth Circuit, and really we had one case just holding on that is great for gun rights in the Fourth Circuit. And the Fourth Circuit is West Virginia, Maryland, South Carolina, and North Carolina. And that's those are the states that comprise the Fourth Circuit Court of Appeals. So there's all these different circuits around the country, depending on what state you're in. And first you look to the U.S. Supreme Court for federal case law, and then you look to the circuits, and it could be different in circuits. So whatever circuit you're in is going to be what's important if the U.S. Supreme Court hasn't decided the issue. So there was a 2013 case in the Fourth Circuit called United States versus Black. And that was a very important case because it was written by Judge Gregory, who was a black man, and he grew up, I believe, in North Carolina with the knowledge and the experience of gun control being used, especially in North Carolina, against the black community to suppress them, basically used as Jim Crow laws. It's undisputable. It's the history of gun control. It has everything to do with racism and Jim Crow and segregation and discrimination. And he grew up in that environment, and he grew up in a family that did have guns for defense of each other. I don't know if they used them for hunting or not. So he's authored several good cases, and he's been on the Fourth Circuit Court of Appeals for a long time, but he's authored several good cases. And he's, I believe, appointed by a Democrat and is lefter leaning on lots of things. But that's the quirky thing about judges, is that you can't just say, well, Trump appointed a judge or Bush appointed. Well, that's laughable. But even Reagan appointed a judge, whatever. I've tried a case before a federal judge who was appointed by President Ford. And I don't know if there's any older than him that are still around, but he's still working hard. But you can't even look at the president who appointed the judge and figure out whether or not, how he's likely to rule on your case. You just can't, because this is a gray area of interpretation of the Constitution. Because while a judge who, like Ginsburg, who finds a right to abortion in the 14th Amendment that says nothing about abortion, well, there must be a right to privacy there, and therefore, if there's a right to privacy, there must be a right to an abortion. Therefore, the 14th Amendment says that you have a right to an abortion in all states, and then the states, even their legislatures, can't stop them. Yet that same judge, late Justice Ginsburg, if anything came up on the Second Amendment, do you think she would try to imply greater rights for the individual, for us, based on the Second Amendment, which is pretty clear what it says? No. She goes the other direction. And then it's the same thing from the other side. If you even Scalia, he's great on the Second Amendment. This is what it says. And looking at history We have a pretty good idea of why they wrote the Second Amendment and how it was used in the 1780s, 1790s, and how firearms were used and the ownership and the types of firearms and what they used them for. But then you get to the Fourth Amendment, and he's going off in the other direction and ruling against the individual and ruling in favor of police on just about every case. And even though the Fourth Amendment is clear, it says we have these protections and that there's a warrant required and so on. He's reading all sorts of stuff into the Fourth Amendment that's not there. So it's a weird gray area, and it's hard to predict what judges are going to do or who's going to be a good judge. And I think the only way to do that is to take people who love the concept of liberty and freedom and is not so partisan in either way. So back on the topic here, Judge Gregory wrote this 2013 opinion called United States versus Black. And that was, I believe it was out of North Carolina. So 2013, North Carolina, there was a right to open carry in in North Carolina. So the cops had basically saw this black guy and he was open carrying, and then they stopped him and got his ID. And the only reason they stopped him was because he had a gun. Well, here's the problem. And maybe they were in a high crime area. It's a great decision. Read it. United States versus Black, 2013. So Judge Gregory calls BS by the time it comes up to the Fourth Circuit, and he says, wait a minute. The only thing you knew about this guy is the color of his skin and that it's a high crime area, which has to do with, it being a black neighborhood anyways. So the only thing you knew was the color of his skin. And you assumed that might be an illegal firearm just based on the color of his skin. And we know that happens, that has happened in the past. The leftists, the Democrats, they want to talk about systematic racism, and they want to focus on the allegation that there's this conspiracy among not just Trump supporters, but cops all over the country, many of whom are black, that they're racist against black people. And they don't say it, but it just comes out, and the violence that and the people that they shoot is, so there's no real data behind it, and it's just sort of race pimping. But here you have an actual history of stuff like this happening that they don't want to touch because it has to do with guns. There's a documented history of racial discrimination in the area of gun possession, gun control. So Judge Gregory says the only thing you knew about him was the color of his skin. And North Carolina is an open carry state. So you didn't know whether he was a convicted felon. You didn't even know his name at the time. You can't assume that just based on the color of his skin or based on a hunch, because that's probably going to be the color of his skin, even though you don't say it, that you can stop that guy and get his ID, even though you have no specific information about that guy, that he had broke any law, that he had committed any crime. So that is U.S. versus Black, came out of the civil rights context with racial discrimination, but it protects all of us of every color. So it protected, as I argued, Michael Walker, even though he's a white guy and he's in Putnam County, West Virginia. It protected him in the same way. United States versus Black says if you don't have any information specific to that individual that he had committed some crime, and that's called reasonable suspicion. That's a legal term of art. It actually means something. If you don't have information specific to that person, that is enough, that is sufficient to stop and detain that person and get their ID and question them and so on, then you can't do it. It's illegal. It's a violation of the Fourth Amendment. Just the gun possession alone, without more, that is not enough to stop and detain somebody. And the officers will say, yeah, but he could be a convicted felon. And convicted felons can't possess guns, or he could have been convicted of domestic violence. He could be a prohibited person in some way under the law and not be able to possess firearms. But if you don't have any information that Michael Walker is a convicted felon, or that he had been convicted of domestic violence, or whatever, if you don't have any information, you cannot just assume somebody may have broken the law. In part because that's what allows racial discrimination to take place. And so that was United States versus Black, and it clearly applied to Michael's case. Clearly applied, and we argued it the entire way. And so they did a little bit of legal gymnastics to say, yeah, but this was close to the Parkland shooting, and he didn't have just any gun that he was in possession with. He had an AR-15, and those are the weapons of war. And that's what was used in the Parkland shooting. And so therefore, an objectively reasonable officer would have been concerned that he was a possible copycat headed to a local school to commit mass murder of children. And therefore, even though open carry of firearms in West Virginia is legal, including rifles, like AR-15 style rifles, even though that's legal, that an officer can do that because AR-15 should be treated separately because they're scary and they're not used for hunting. All this stuff that they said, even though that's not true, and it had no basis in the facts, whatsoever. There was no information about a school in the underlying facts. You can watch a video of the event. There was nothing about a school ever said. In fact, after they eventually let him go, they didn't even follow him to see if he was headed to a school. I mean, how objectively reasonable is a fact like that? There was no mention on the radio of a school. There was no mention on the video of a school. They didn't follow him to see if he went to a school. It was just something the lawyers came up with after the fact. And, so the end result is they're trying to get a ruling out of the Fourth Circuit that it accepts AR-15 style rifles from the holding of U.S. versus Black. So what does that mean? That although you can open carry in West Virginia or North Carolina or Virginia, they have an exception for AR-15s, because if they see you with an AR-15, it's a weapon of war, it's a weapon of mass murder. They can stop, they can disarm you, they can get your ID, they can run your background check, and so on. Whereas if it's a pistol or even a shotgun or a bolt action rifle, believe it or not, under what they're arguing for here, the officer can't do that. So he'd have to have some actual reasonable suspicion that you committed some crime. So it's asking the court to overrule essentially United States versus Black. Basically a civil rights case, an important civil rights case, in addition to an important gun rights case. So that is being heard on March 8th. So you're going to want to stay tuned to that and see what the court does. And all the other lawyers that have heard about it are like, oh no, I mean, the Fourth Circuit, they're gonna rule against us because that's been their track record. But I'm optimistic, and they came out with a case out of Richmond. I think it was called Woods here just a few months back, where they found that the police officers had violated the Fourth Amendment and coming to the scene of a shooting and stopping this guy they saw that was kind of limping off like he had a gunshot wound. So I think it was USA versus Woods. And so, that is not really what I was expecting to see from the Fourth Circuit. So I'm, hopefully just the gun part of it doesn't, overrule in their mind what they would usually have done. Sort of like a Trump derangement syndrome. It's like a firearms derangement syndrome where legal principles can suddenly change just because one doesn't like firearms. Okay, and as this is going on, we've all heard what Biden's trying to do. And if you're surprised that Biden's coming after guns, I mean, I don't know where you've been. He said that he was. He got Beto O'Rourke to be his proposed gun control czar, back during the election. So he's made it very clear that he's going to do whatever he can possibly do to enact new gun control. And I'm surprised we haven't seen an executive order already. And probably the reason is because he knows, there's enough Second Amendment law out there that he knows, or he's been advised, that if he issues an executive order that goes too far on the gun rights issues, it's going to get shot down. And why do that when you have the Senate and the House of Representatives? So he can get it passed through Congress. So it looks like that's what he's going for. Which brings me to the state legislatures. So again, our legislature in West Virginia is supposedly supermajority, 70% of Republicans, allegedly, who strongly support the Second Amendment, allegedly. I hope that's true. The West Virginia Citizens Defense League, and which is sort of the West Virginia version of the Virginia Citizens Defense League, I believe is the same name. It's basically the gun rights organization for our state, has gotten a lot of great legislation passed through the state legislature. And so they came up with this bill this year, and it's been introduced, and it's going back to, or it's in that very same, I believe, Judiciary Committee. And it's essentially non-enforcement. It's a pact of non-enforcement of federal gun control efforts. So it's asking, and I put this on the website at thecivilrightslawyer.com. Maybe I can bring it up here. It's sort of a resolution from the state legislature, and this has been done in some other states, to not enforce or participate in any federal tyranny as far as gun control goes. Let me pull this thing up here. All right, so this is my website here, my blog, and this is a post I did on February 12th. The West Virginia Citizens Defense League proposed legislation for non-participation in the enforcement of federal firearms restrictions. So this is before Biden said anything, but again, we knew it was coming, and it's time for the state legislatures to flex their muscles and flex their state sovereignty if we have any. So this is really about more than just the sanctuary, the sanctuary city or sanctuary, Second Amendment sanctuary stuff, which was meaningless. For instance, this Michael Walker case I've been telling you about happened in Putnam County, West Virginia, which just so happened to be the first county in West Virginia to become a so-called Second Amendment sanctuary. So that tells you that they're in federal court right now arguing that AR-15s are weapons of war. And I don't think they're a Second Amendment sanctuary. Never were. So that's really a joke. But this can work. This is good. Non-participation and enforcement of federal firearms restrictions. So this is a way for the state to resist the enforcement of any federal law, because most of these federal laws are enforced by the state, by state police officers, by county, by local police officers. So this is of course we can't stop the feds from coming in and arresting people and charging people in federal court, as we've seen with the January 6th event, where they've arrested people here in West Virginia. The state can't stop them from doing that in the context of new gun control efforts or gun confiscation efforts, but we can not help them. So where they've done this in the immigration arena, created these these resistance, these real sanctuary to illegal immigrants, we're sort of proposing doing the same thing and with gun rights. So if you go to the website here, I link the actual white paper document that they prepared, and it's not real long. You can read it. and look at the proposed legislation. This is really all of the, this is the as they call it, the priority legislation of 2021 for West Virginia gun rights. So if you're in West Virginia, make sure that your legislators know that you want this enacted to protect you against Joe Biden and Beto O'Rourke and whatever other clowns they have trying to take our gun rights away here in West Virginia. And same thing in other states. It's going to be up to your state legislatures to defend us against the federal government. So just briefly, the impeachment trial. I mean, I did a video or two on the last impeachment trial. I didn't even feel it was necessary to do it again, because the last one didn't really, and that was more about high crimes and misdemeanors. And as we know now, there was no evidence there of anything. And the whole impeachment idea was more about removing somebody who's dangerous from office. And it's a, it when you see it sort of deal. And this was just absurd. And all you needed to know really was that John Roberts, the Chief Justice of the U.S. Supreme Court, wasn't even going to preside over it. I don't know if that was his choice well, obviously it was his choice, but I don't know what the stated reason was, if there was any, but that's all you really needed to know, where you have Patrick Leahy presiding over it. I mean, that's absurd. And you get something like you got, which was a complete and total lack of any due process. You had, for instance, the video that was altered in many different ways being presented. And that's what people were watching and saying, oh, it's so powerful. I wasn't really convinced, but now I'm convinced. It was just so powerful. Well, first of all, in a real court, and especially federal court, I mean, you can't do that. You can't present like your own produced video like that. It's just not going to happen. You can present video once you get it entered into evidence and authenticated, for instance, body cam footage or surveillance footage, but you can't cut it up and add, production quality to it and narration. I mean, I didn't even watch it, but I can guess about what it looked like. You can't do that. It wouldn't be admissible in any real case in the land, criminal case or civil case. It just wouldn't. Then you had this punk Eric Swalwell, who's an absolute joke, who got caught with Fang Fang, the Chinese spy, yet he gets to remain on the Intelligence Committee. He apparently doctored a tweet, added a blue check where there wasn't a blue check, changed dates, or did some other things. If you did that in a real courtroom, you'd probably get disbarred. In fact, I saw a guy, well, I don't want to say disbarred, but I saw a very, very important lawyer. I'm sitting at the West Virginia Supreme Court years ago, waiting to argue my case, and he's got his disciplinary case on in front of mine. And he was a big deal at a big law firm, and he got suspended for I don't know how long just for leaving the last page off a medical report. And I think that was like a black lung case or something like that. Like he just omitted the last page, and he said, he was including a portion of it, or I mean, he had a reason for it, but I mean, they hammered him, not for actually changing it, just for leaving one page off. Can you imagine what would happen to you as a real lawyer by any judge or disciplinary authorities if you got caught presenting a Twitter or a tweet into evidence, say in a criminal trial, and you had doctored it and you had added a blue check mark where there wasn't one to make it look more credible and more authentic, and you had changed some of the substance of what was allegedly tweeted? Oh my God, you'd be destroyed. You'd be, I mean, and you'd lose the case as well, or there'd be a mistrial. I mean, no doubt about it. And yet you had that here. So it was, I mean, I watched as little as I could because it had no real relation to any sort of due process as you would see it in either a civil lawsuit or a criminal case. It, it was an absolute disgrace in my opinion. And so here's the deal. If Trump committed insurrection, if Trump committed any crime, then charge him with it. They said that they would anyways. Charge him with it and do it in a real courtroom. And yet they didn't, because there's no evidence of it. There's no evidence of it because it wasn't incitement. You can look at the case law and it's protected First Amendment speech. It absolutely is. Donald Trump had a First Amendment right to say the things that he did. There's not an exception where it doesn't apply to a sitting president or a political candidate or anybody. If he had said, all right, we discussed this. Let's round everybody up. Let's go to the Capitol and let's storm it. And there was evidence that there was communication and a plan to do this. I mean, if you had all that sort of evidence, then yeah, we wouldn't be hearing about an impeachment because he would have been indicted. Absolutely. But that evidence didn't exist. There was no evidence to actually charge him. So they're just using the vague high crimes and misdemeanors standard, which, what does it mean? No one really knows. No one really knows. It depends on who's being impeached. When Clinton was impeached, you had, 400 law professors writing letters to the Judiciary Committee describing how it wasn't enough to meet the criteria of a high crime and misdemeanor, because it has to be something just real monumental and presidential and a threat to the very existence of our country and the operation of our nation, and you know it when you see it, sort of deal. And then you had the first impeachment of Donald Trump. Those same 400 law professors again wrote letters to the Judiciary Committee, pointing the finger at Trump, saying this is enough, this is enough, this is enough, even though they had completely different opinions during the Bill Clinton impeachment. And by the way, after Bill Clinton was impeached and acquitted, he settled the civil lawsuit with Paula Jones for like $800,000. And he also got disbarred or suspended from his law license in the state of Arkansas. So there actually was evidence of wrongdoing, and there actually was disciplinary action. Well, I wouldn't say convicted of that took place against him, and he paid almost $1 million to this woman, and that adds a lot of credibility to the allegations against him. And there's nothing anywhere approaching that with Donald Trump, and it's just an absolute. It's sad for our state that we have Manchin who voted for it, and whether or not Manchin actually wanted to vote for it, we don't know. We all can remember, or if you can't remember, look it up. I think it was the first State of the Union or one of the State of the Union addresses where Manchin liked something that Trump said and he wanted to stand up and clap. And as he's standing up to clap, he looks over and sees Chuck Schumer, and Chuck Schumer glares at him. And so he kind of halfway stands up and he sits back down. So he clearly does what Chuck Schumer tells him to do. So who knows what he really wanted to vote for here. But it's just an absolute disgrace, and it's against the overwhelming majority vote of his constituents. And so our other senator, Shelley Moore Capito, has to virtue signal and say that President Trump was disgraceful. Well, we'll see how that holds up for her in her next election. But the fact is that once these people get into power and they're able to get people all these different jobs and other things that they want, and they have all these handouts, and they get their buddies in positions of power, it's almost impossible to remove them. So if you, for instance, you got your people running the state political party. Well, how's anyone ever going to primary you, even under these facts, when they have the state political party working against you from day one. It will never be a fair playing field. It'll never be fair enough for anyone to win. So will they actually be defeated? We'll see, because it's sort of a fiction that any of the electoral process is fair. I mean, it's all designed to keep the incumbents in power. All right, Donnie Fincher, interested in my take on companies being legally able to require vaccination. Now, I'm not an employment lawyer. That's not what I do, and I don't advise companies on what to do, and I generally don't even sue companies over wrongful terminations. I more deal with public employees and public employers, because the Bill of Rights is applicable to that situation, where it's not applicable to the private employment situation. But I have had people call me and want advice on this, and I've had people ask me about it. And in fact, I had a TV news reporter contact me today and ask me for an interview on that exact topic, and I gave it. That's probably run by now. So I had done some research on that, and I've followed it. So I can tell you what I think the law is, though I'm sure there are other lawyers out there who are better suited to give an opinion on this. But this is the law as I understand it right now. I'm not saying it's right, but this is sort of the consensus in the legal field. And that's this. And we're talking about mostly private employers. And can they force you to take a vaccine? And under the current guidance, are they being told they have to force you to give a vaccine? From my understanding right now, there's a lot of information at the EEOC website, the Equal Employment Opportunity Commission website, and it has a lot of questions on guidance for companies on how they handle some of these COVID issues that are coming up. So here's my understanding of the law as it is right now, is that generally, if companies want to require you to take a vaccine, can they do it? Yes, generally. Now, that doesn't mean that you can't sue them and get away with it. I'm looking for my notes here. Doesn't mean that you can't sue them and get away with it, but just under the law as it sits right now is, yeah, they probably can do that, though there are exceptions, primarily two exceptions. All right, I don't know what I did my notes on that. All right, so I'll have to go from memory here. So generally, yeah, they can require you to take a vaccine unless you have a disability that would fall under the ADA exception, or a religious exception. And so most of the people I've talked to have, I don't want to take the vaccine either because I don't want to take any vaccines. I'm an anti-vaccine person, or I'm not an anti-vaccine person, but I know this one was rushed through. I don't believe it's safe. I don't want to take it. I think most of those people could probably fit within the religious exception, or that might be the most applicable, because if you look at the law on the religious exception, and this is under Title VII. So there are two statutes here. The ADA is one, federal statutes, and then Title VII is another one. So the ADA has to do with disability, and the Title VII statute has to do with religion. So I'm talking about the religion. Now, it's not just I'm a Christian, therefore, or I'm a Muslim, or I'm Jewish, therefore. It goes deeper than that. So it has to be a sincerely held belief, but it can be just a moral or ethical belief. It's not necessarily, it doesn't have to fit into a major religion, but it has to be a sincerely held ethical, issue with taking a vaccine, or a moral, deeply held, sincerely held issue with taking a vaccine. It has to be something like that to fit in with this religious exception under Title VII. Now, I've never personally litigated that, so maybe there's a lot more to it, and it won't work. But I think that's probably the best bet for those types of folks and that seems to be most of the people I've talked to. And then you have the actual disability exception under the ADA. Now, what could fit that? I don't know. Some sort of disability where you could get your medical provider to say that you can't take the vaccine. So I'm not sure what that is, that you have some sort of medical issue that you can't get the vaccine. So I think if you do that, those are the two ways that you can get around that. But that being said, under even the current guidance from our tyrants, employers are not asked to do this. They're being asked to request it or encourage it, but not to require it. And in fact, there's a lot of guidance showing that if you do require it, then you're opening basically a can of worms. Because then how are you going to enforce it? Now you're going to have proof. And so you've got to be very careful about what kind of proof you get, because now there are privacy issues and HIPAA issues and all sorts of other ways that now they can get into hot water. Anytime you're dealing around a person's medical disability, you're forcing them to disclose something that they don't necessarily want to disclose. There's all sorts of problems for employers from what it sounds like for me. Again, I don't advise employers. So I'm not, never been general counsel or anything like that for a corporation. So maybe I don't quite understand, but the current guidance is not for them to force vaccines, and that if they do, they have to be very careful. There's all sorts of other issues, and it's not going to be held against them if they don't mandate taking vaccines. The other thing that really I learned is there's a difference in types of jobs. So, and this goes a lot to the disability, the ADA. So under the ADA, say if you do have a disability, your medical provider says that you don't have to, or you can't take the vaccine, period. And that would harm you in some way. And that qualifies as a disability. Well, the employers don't always have to accommodate that. So if you have a disability, the ADA says that they have to make reasonable accommodations. Now, what's an unreasonable accommodation? So in this case, an accommodation is allowing an exception for you not to get vaccinated. So the law says that if it's an undue hardship on the employer, then they don't have to accommodate you. So where could that apply? Where would it be an undue hardship for an employer if they were to make an exception for you? And that's probably going to be in the healthcare field. So, hospitals, nursing, stuff like that, they would be on stronger grounds to force somebody, even if they had a disability of some sort that qualified under the ADA, to force them to get vaccinated or else fire them. As I was researching this, I thought, I guess this applies generally to public employers as well. And of course, the ADA, I think it only applies to, was it employers? Again, don't quote me on any of this. I'm just speaking generally, but I think it applies to employers over 15 employees. But a lot of these same rules also apply to public employers. So it applies to the government. And I'm not sure about the federal government, but it applies to state, local government, political subdivisions, counties, cities, things of that nature. Those laws generally do apply. And I was reminded of when I worked for the federal government, when I went to work for the Department of Justice and went there on my first day of work in Washington, D.C. on Pennsylvania Avenue. The first thing that they did, the other new people that I was with, is they took us to some underground, before we did anything, it was like some underground, it seemed at the time, some sort of secret medical lab. And they started sticking me with needles first thing. And they were inoculating me for all sorts of stuff. And the reason is because I was going to be going into all these jails and prisons all over the country, investigating civil rights violations. And they made me watch a video that all these inmates are going to be throwing their poop at me, and God knows what else. And there's going to be all these awful things I was going to come in contact with. And that's why they require you to get all this stuff. And they shot me full of all sorts of things. And years later, maybe it's related, I get this rheumatoid arthritis, eventually diagnosed with with lupus and rheumatoid arthritis. And first symptoms I had was basically my hands started going numb, and it just sort of went from there. And it was just inflammation in my joints. And so I went to a rheumatologist at UVA. And so the first thing that they do when you go to a rheumatologist, if and when you get to see one, is they run like every test on you. They run blood test after blood test. I mean, they do every kind of scan there is. And so after all these blood tests, he calls me in. He's like, so have you had like XYZ awful disease? Like, I don't understand why we're seeing that. So I guess you get like inoculated for all these awful forms of this, that, and the other. It shows up in your blood work. And so that's when I'm like, oh yeah, well, that's probably all related to the Department of Justice, whatever they stuck me with, that it's still today, I guess I have the antibodies or whatever it is still in my system. And come to think of it, maybe that is part of the reason that my immune system's so screwed up right now, that I got all these crazy vaccines. Maybe some of them weren't safe. So I understand that completely. And I don't know that I have any interest in getting that vaccine. I haven't really thought about it because it doesn't matter. It hasn't been offered to me anyways. But I've talked to a lot of people that feel very strongly. And I want to say that I think that they should be able to fall in through that religious exception, which again is not like, doesn't have to be a tenet of your religion, just has to be a sincerely held belief. And so what if that's disputed? How do you prove it? Well, there is a mechanism where you can gather affidavits, or they get affidavits of people in your family, people you work with, whatever, that to prove that this is a way you felt this before this vaccine came about. It's not just about this vaccine. It's about something you feel about all vaccines. So that's probably the strongest case you have, is if you're just an anti-vaxxer and you don't want to take any vaccines. And I think there are probably other issues, and I haven't really tried any of this, especially with public employers, of where if you're mandating somebody to take this vaccine into your body. I think there's all sorts of other federal constitutional rights that could be implicated based on the circumstances. And again, there's a difference with private employers and public employers. So private employers, the Bill of Rights, unfortunately, doesn't apply to them. Public employers, and if you're able to identify First Amendment right, having to do with vaccines, which might be a good claim. I haven't researched it, but that would apply to that public employer. If you're a school employee, for instance, that wouldn't apply to, your private sector IT job. So that's in a nutshell what I understand to be the law as far as employer forcing vaccinations. And I'd also looked into the law of employer forcing COVID tests. And yeah, that's a much clearer set of circumstances. I mean, employers are allowed to test you for COVID. And I talked to some people that they were having to get tested like every day, and they were pissed about it. But it's all been upheld as far as I know. So, but the vaccines, I think I'll be surprised if employers actually start doing that, because like I said, in the end, we know they don't care about any of this stuff. They will virtue signal. They will fire your ass just the virtue signal for 5 minutes. But if it cuts into their bottom line, if their insurance rates go up, and they start getting these lawsuits having to do with medical, disability privacy stuff being disclosed. I mean, they start getting into that stuff. And I mean, all right, then the virtue signaling's over. They're back to business. So I don't think, that's just my guess, is I don't think we get to the point. I think the more likely scenario is we get to the point where the government is forcing, it's not employment related. You just have Joe Biden issuing an executive order forcing some group of people or all people to get vaccinated. I think that's more likely. And that's an entirely different video and legal analysis. And I think that's a much more difficult case for the government to make. Losing my voice here. Yeah, Karen O. That's a great point. Well, maybe I missed your point here. There it is. It's a private decision, just like abortions. But there's a double standard, and they don't even care anymore about demonstrating the double standard. It's just like science. You try to fight against a mask mandate, and you'd think all these liberals. I mean, I don't even want to call them liberals because they're not. They're more of just leftist. I would suppose, or you could even call them fascist. I mean, it could be on the right too. They want to force their agenda on you. They have some larger scheme that they're involved with, and maybe they're just useful idiots and don't know any better. But they want to force you to comply with what they want. And for instance, the COVID stuff. I mean, who would have ever guessed what has happened with all this mask stuff? And I was saying very early on, this is going to be the end of us. I mean, this is insane. Just what we've gotten to with the mask stuff. It's absolutely changing our culture. It's harming children, in my opinion, my unscientific opinion. It's harming the mental health of people across the societal spectrum. I mean, I think it's one of the worst things that's ever happened to our country. Again, my unscientific opinion. And if you try to bring it up, you get accused of being against science. You get mocked, and it's all about science. So then all right, well, what about transgender athletes with LGBTQ plus minus whatever? And if we try to say, well, no, we don't want men who believe, well, strike that. Let me put it this way. If they have their way, we are no longer free to have an opinion on this issue. So if our opinion is, that man may think he's a woman, but I don't believe he's a woman because of science. Scientifically, he's not a woman. He's a man. I don't want him in the locker room with my kid. I don't want him on my daughter's volleyball team, track and field team, whatever. You're not going to be allowed to have that opinion. You almost don't now. You're not allowed to have an opinion. There's no option for disagreement on this topic. And if you try to say science, you can't use science as an argument. Science doesn't apply to that issue. And on your point of abortion, science doesn't also apply. It's just about inconvenience. So I get mocked for not wanting to wear a mask and told that, it's not all about you. It's not all about you. You just wear the mask. How selfish of it is you. How selfish is it of you to not want to wear a mask because it's just a minor inconvenience, and you're showing that you care for other people and you care for those around you, and you're saving lives. And it's science. You can't question it. Are you a virologist? No, you're not a virologist. I didn't know you were a virologist. How many people have said that to me? I've had so many people say that to me. Oh, I didn't know you were a virologist. And so that gets shoved down your face. And science. But on the transgender issue, which, who knew that was going to be, the issue of the day either? At any point in world history up until now, the word science is not to be heard anywhere. Or abortions. If the science shows, it shows what it shows. You have a baby growing in the womb based on the gestation. You can estimate, what the size of the baby and the organs in the baby that are working. There is science behind it. It's unquestionable. Yet we're told that science doesn't matter. That's not a person, even if science says, proves that it is. That's not a person, that's a choice. So science doesn't apply in issues that they want to impose on us. But science does apply. It's sort of like the whole Capitol protest. They believe nothing, really. They believe nothing. And not all of them. But They believe nothing. The Capitol protests, like, all right, the left, they love cops now. They love cops, and they're crying over the Capitol Hill police officer who allegedly was killed with what was it, a fire extinguisher that later came out that he had a stroke or something. I mean, he's lying in state, and they're having, they're mourning over the lives of these police officers, and they all of a sudden care about the police. I mean, you believe that for a second? No, no, they just got done of firebombing businesses and destroying communities because they hate cops so much. But they're disingenuous. They, when it helps them attain their political goals, then all of a sudden, they love police officers, and the police officers are heroes. And same thing with the military. The National Guard is called out to defend them and defend Joe Biden, or supposedly defend Joe Biden. They're all of a sudden pro-military. But, the last however many years back to the Bush administration, they've hated the military. And this is probably nothing you haven't noticed yourself, but it's just the double standard is, and of course it's all predicted. I mean, everything you need to know about life going forward. I mean, really, it's all in George Orwell's Animal Farm. And if you haven't read Animal Farm, read it. And if your kids haven't read Animal Farm, there's actually a graphic novel of Animal Farm I bought for my kids, and it's a great way of not indoctrinating them, but teaching them why you're right about this. And it's not just kids. I mean, teach anybody. And it follows what happened in Russia from roughly the end of World War I to, the end of World War I till about World War II. And it follows what happened in Russia, but it applies to really any authoritarian regime, or communism or socialism or whatever ideals that these kids are taught now in the public schools and in the colleges. That if only we did XYZ form of government, it would be great. It would be this utopia. Well, who are they? They think that this hasn't been done before. That's exactly what happened with Karl Marx and communism. Is it started out as this wonderful idea of this utopia, but in reality, what happens, and it happens every time, is that once they take over, once people get in power, it doesn't become a utopia. For whatever reason, it doesn't. Whether it can't, or it's just human nature that it doesn't. It turns into an authoritarian regime. And that is what it's happened over and over and over again. It's very clearly demonstrated in George Orwell's Animal Farm. At the very beginning, you have the evil farmer, and he's mistreating the animals. And we can all agree that the animals are, they're so mistreated. It'd be great to take over the farm, and they could have this great farm without the farmer, and life would be grand. And so they overthrow the farmer. And then what happens? Because all animals are not equal, never will be. Some are smarter than others. Some are more evil than others. And you have the pigs. You have the pigs in Animal Farm. And those are, they're smart. And you have other animals like the horses that aren't smart. So the pigs naturally take the lead, and they write up all the rules. And there's this big, long list of rules. And then over time, the rules are changing and getting shorter and shorter and shorter. Whereas at the end, the only rule left on the board, or painted on the barn, is that all animals, some animals are more equal than others. And the reason is because the pigs started to violate the rules. And when they got called on it, they just find an exception, or then eventually they'd have to change the rules. And to the point where there were no rules at the end. It was just some animals are more equal than others. And the pigs have now become the farmer, and life sucks. So it's even worse now than under the farmer. And that's the entire point. But a lot of people, I think, don't understand that. And, I'm glad that I even read a lot of Orwell early on. And I think that helped shape the way I see things, and not because it indoctrinated me, but because it it allowed me to relate to it. And then I see in modern society these things happening. So let's see. Yeah, sorry, I was talking about abortion there and somehow got onto Animal Farm. All right, so I need to get off of that. Roxanne, War and Peace, the brothers Karamazov, Fountainhead, Catcher in the Rye, Sense and Sensibility, all great books. Brad Birchfield, I predict you see shootings start to happen now that Biden wants common sense gun laws. Well, I don't know what's going to happen, but I do know this. All this insurrectionist BS. Look how easy it was just for 100 or 200 people to just go in the Capitol. No weapons. They weren't armed. Regardless of what you see in the media, they weren't armed. There may have been one or two people that had a concealed weapon somewhere that never came out. Also, the pipe bombs that were elsewhere are irrelevant. I mean, they were, according to the evidence, set there like the day before. But there's never, to my knowledge, been an unarmed insurrection in human history. By definition, an insurrection, especially against the most heavily armed country in the world, the strongest military that's ever existed on the planet, how could 100 or 200 unarmed people commit an insurrection? The fact is that imagine not just if those 100 or 200 people were armed. Imagine if the 100,000 plus people that were there all did participate in storming the Capitol. Imagine if they really wanted to commit an insurrection. It would have been a piece of cake, at least to a point. Then it's like the ending of Finding Nemo, where they finally get out of the dentist office and plop into the ocean, but they're still in the bags. And one of them looks at the other and says, now what? So I don't know how that would happen after the fact, but if it was really an insurrection, then there'd be no question in your minds. It would have actually been very easy for them to do. I mean, if they actually had guns and wanted to, and just say out of the 70 or 80 million people who voted for Trump, how many of them are gun owners? And if they really wanted to participate in an armed insurrection to commit a coup, would they be able to do it? I think that maybe that's what has scared them so much, is just how easy it was for 100 or 200 people who were unarmed to have their way with the Capitol. So I think that's why we're going to see such a push for gun control here, because now they're terrified, because they see if that's how dangerous an unarmed populace is, imagine if they were all armed, and imagine if they had AR-15s, if they had these weapons of war. And they're not going to allow us to have them just based on that possibility. So what's going to happen is if they try to confiscate them, take them away. I don't know. It'll be interesting to see what happens. You've already had some of this with the red flag laws. I think that's where, we don't want we don't want any option to have to be violence. I think our best option as a country, as citizens who respect or want to keep their Second Amendment rights, is to live in a state like West Virginia, where your legislature is going to protect you from the federal government overreach. So if the state of West Virginia says that regardless of what the federal government says, our people can have guns, and not only that, they can have guns XYZ and do XYZ with them. And what's the federal government going to do? I mean, there's going to need to be a legal battle between the states and the feds in states like West Virginia. And I think it'll eventually get to the Supreme Court. And I think that'll have to be fought before we have anything resembling confiscations actually happen. But who knows? All right. State is a fictitious entity. It isn't real. Didn't tell you to do or not do anything, doesn't speak. Well, West Virginia was created 1863. We were Virginia. I mean, the colony of Virginia was real. There's no dispute that the colony of Virginia was real. And there's no dispute that following the Revolutionary War, the colony of Virginia became a sovereign state. It wasn't forced into entering the Union, never was. It agreed to enter the Union voluntarily, as with the other states. And that's why it was presumed at the time of the Civil War that if they were able to enter the Union, they should be able to withdraw from the Union. Obviously, that didn't happen. That wasn't allowed to happen. But, I don't know about the fictitious entity stuff, but Virginia, North Carolina, South Carolina, Pennsylvania, I mean, they were real. They weren't fictitious. And, I think you can trace, Virginia, for instance, I have law books from Virginia that go back to the 1600s. You can trace it. I'm not sure. We went from colony to state, but there's a paper trail for that. Underground auditor. We citizens can remove them with a writ of quo warranto. Please look into this. I have actually looked into that. I had a friend of mine ask me about a writ of quo warranto, and I didn't really know what it was. So I researched it, and I think it's a good point. It's a mechanism. If you don't know what a writ of quo warranto is, it's a writ just means, you're asking the courts to force something. So I think what it was to remove public officials who, violate our rights, do this, that, and the other. So I looked at the case law. When has quo warranto ever been mentioned, for instance, in West Virginia? And there actually was case law on writs of quo warranto that were filed in the past, but they were all a long time ago. They were all around late 1800s, early 1900s. I didn't find anything that was recent. So I don't know what would happen if somebody tried filing one. Well, I think I do know what would happen, because you're still going to a court and asking them to issue one of these writs. And I've done that several times now, and they never do it. So I think that would be a result is just they wouldn't do it. All right. Robert McKay, where's the paper trail for the millions of Aboriginal people that were here before us was thought of? Well, I'm not sure what that has to do with what I said. I'm not disputing that there was a beginning to the colony of Virginia, for instance. There was a beginning of it. I guess you could say it started in 1607 when the first English settlers landed at Jamestown. Now, obviously, there was no paper trail really anywhere in North America, far as I know, showing the exchanges of land which had already taken place with the Native Americans who were there already. There were already wars that had occurred between them. There probably were other forms of records. I think maybe a lot of oral tradition, but there were also, wampum belts and marks on trees and probably a lot of these burial mounds. And there were lots of, they didn't have a society where they had paper and wrote things down. And so, yeah, did we come over and conquer it along with every other European power? Yeah. So there was a paper trail from then forward. So I don't know if that answered your question or not. All right. The writ doesn't need to be done or approved by any court. It's a citizen's right to remove our politicians. Oh, so you're saying you're going to do it without a court order. Well, yeah, I mean, that could, good luck with that, because I mean, I don't know. Why call it a quo warranto then? You know, why call it a quo warranto? I mean, don't you just already have a natural right to life, liberty, and pursuit of happiness? You know, I think if you're if it's a writ of quo warranto, that means it's going. I mean, that's going to a court. And if you are issuing the writ, I mean, basically you're just, well, I guess they'd call you an insurrectionist. Yeah, in Pennsylvania, writs are used often. Well, they're used here as well. In fact, I just sued our governor under a petition for writ of mandamus here for the second time here in West Virginia. So yeah, writs are used, but they're generally now you see a writ of prohibition or a writ of mandamus or a writ of habeas corpus. I've never seen a writ of quo warranto before. Though they're there. You can look it up in the case law. Okay, Robert. I guess I see your point here. So your point is that the paper trails, yeah, we have a paper trail, but the paper trails have a way of being changed or disappearing historically. Yeah, well, I suppose that you do have a point there, but I don't know that anybody would dispute the fact that Virginia was a colony of England and that it was actually set up with a charter with a private company coming to try to make a profit here in the New World. I don't know that anybody disputes that paper trail, which still exists. And then, from the very beginning, they established the capital there of the colony in Williamsburg after Jamestown. I mean, all of that paper trail exists. And that exists all the way through the Revolutionary War and then the colony of Virginia ratifying the Constitution. Now, did something change after that? Did something change with the Civil War? Yeah, a lot of things changed, but and then West Virginia, of course, was created. But I don't know. I guess I don't get the point of the state is a fictitious an entity and what that does for you, anyways. Okay, T-Bear Rails, referring to the U.S. versus Black case, Fourth Circuit, 2013, or I think you're talking about my case that was arguing about Black. So your question is, was the school out of session for the day? Seems as though it was close to dark, so the school angel would not hold water. Well, that's a very, very good question. Now, their argument is that school was in session. In fact, that was the testimony on the record. Now, I didn't know it at the time, but we found evidence that the time was like 6 or 7 in the evening, and then I realized, well, hell, you can hear crickets on the video, and I'd never even thought about it. Well, I actually researched that and brought it up in court. That the crickets really only appear at night, and therefore there's no doubt this happened in the evening. School was not in session. So we were able to prove that. But they argued to the court that since it was, and this is laughable, but since it wasn't brought up earlier and wasn't a part of the record, that we couldn't use it. And the court agreed. But here's the thing, the whole scary black rifle mass murder of children defense had no basis in the factual record whatsoever. So yeah, it did happen at night. And so then what they did is they presented a list of sports and after school activities that were in effect on that exact day. So that was their defense. Well, all right, school wasn't in session, but there probably was somebody there. So that's a good question. No, it didn't hold water at all. Chaos Stream Network. Crickets at night are good proof. Well, I'm not sure if you're being sarcastic with that, but yeah, I think if you have a jury, that'd be great proof. I mean, you have some old timers on the jury, and they've lived out in some holler somewhere in West Virginia their entire lives and and they know damn well that you don't hear crickets in the morning. They'd probably shake their heads like, "Yep." Now, do the federal courts care? Does the Fourth Circuit care? I don't know. But we also had a timestamp from the video that we found, and then I also found a 911 communications center record that showed the date of the call, the time of the incident. So we were able to establish beyond any doubt the time that happened. It was in the evening. But the school shooter argument was BS from the beginning. And another way I could demonstrate that it was BS is because they claimed that he may have been a copycat shooter. So when you look at the facts of the Parkland shooting, he didn't get there by openly carrying an AR-15 down the side of a road walking to the school. In fact, he took an Uber there, and he had his AR broken down into a black duffel bag. So you could have seen him walking down the street or arriving from his Uber. You could have seen him get out of the Uber and on school property, and you wouldn't have seen an AR-15. And there would have been, so nothing that he was doing was copycatting the Parkland shooter. There was really no similarity whatsoever. The only thing that this had to do with the school is that both AR-15 style rifles were in both circumstances. That's it. But no officer from that position would have known that. And that's about it. There's really had nothing to do with the Parkland shooting whatsoever. It was just used, which is pretty despicable. It was just used by the cops and their lawyers to try to get themselves out of liability. That's all it was. And that's pretty despicable, especially for them to say that, all right, I was concerned about these kids and down the road. And all right, so then when I ask them, all right, well, did you follow this individual, or you just let him walk away? Well, I let him walk away. Well, where'd you go? I went and did something else. Well, what'd you do? I don't remember. But you didn't follow him? No. Did you ask your partner to follow him? No. Did you ask someone else to follow him? No. So the fact is you didn't say anything about a school that day, did you? No. You didn't say anything over the radio about a school, did you? No. You didn't ask Michael if he was heading towards a school, did you? No. In fact, the first time you ever mentioned concern about a school shooter was sitting next to your lawyer at a deposition, right? Yeah. Yep. So, I mean, it can be shot out of the water very easily. Has nothing to do with any real legitimate concern that he may have been a school shooter or a copycat. All it has to do is the cops wanting to be able to stop and ID anyone with a firearm, and that's what they want. Maybe not all the cops, but all the leadership types that make the decisions. They want that. They want to be able to do that. If they see a firearm, they want to be able to stop the person, forcibly get their ID, run their background, run their ID, and see if they're a prohibited person, see if they have any warrants on them, and all this, that, and the other. That's what they want to be able to do, and that's what they're arguing. I mean, they're not really concerned about kids. Never were concerned about kids. So that's. I hope I answered your question there, Thomas. And that's a good point. It's okay for the cops to have ARs, but not the people. And then that's where they conflate hunting with the true purpose of the Second Amendment. So the Second Amendment has nothing to do with hunting. It's not there to protect Americans from tyrannical deer or anything like that. It has nothing to do with hunting. It has everything to do with self-defense. self-defense, and using military capable weapons like the muskets were, musket with a bayonet back at the time that the Constitution was ratified. So yeah, I mean that's a good point and that gets brought up in cross-examination a lot. When you're cross-examining cops on some of these issues. So if they try to say that an AR is and this has come up in the self-defense scenario, well, more so with AKs, but ARs have come up like if you have an AR, then it wasn't for self-defense. You were planning some sort of illegal activity. When the reality is that if you're defending yourself anywhere, especially in your home, what wouldn't you rather have a AR-15 than a pistol? Cops know that. Their departments know that. That's why they issue them those now. Our military knows that. If you can have your choice a weapon to defend yourself with in a life or death situation, you'd rather have a rifle with 30 rounds available that is extremely accurate and whereas a pistol is much more limited capacity generally, and it's much more difficult to hit what you're trying to hit. So it's much safer for the person who's defending himself or defending their family. I mean, that's what the Second Amendment's about. That's why cops have ARs, to defend themselves and other people. That's why we have ARs, to be able to defend ourselves and other people, or at least that's why we have the right to have them. But then there's this fiction that the Second Amendment doesn't apply to anything outside of handguns or hunting weapons. And it is true that the Supreme Court has only extended the Second Amendment as of today, as of right now, to handguns inside the home. They have not extended it outside the home, and they haven't extended it to even AR-15s inside the home. They haven't yet. Hopefully they will. And I think you'll see those cases coming down. But as of right now, I mean, you look at the Heller case, the McDonald case, all those apply to is handguns inside the home. So that's why the Second Amendment itself is not a great claim for any of these, or defense to any of these gun rights cases. The best defense, the best legal foundation is usually the Fourth Amendment. That's why the U.S. versus Black case is so important. All right, I'll leave it off with this, and that's a quote a long time ago. If you look at my blog, I've had that since like 2007, maybe 2008. Early on, I had that same quote on my blog. I used to say it off to the side. Nothing great in this world was accomplished without passion, and I believe that to be true. And and history, I think, is an important part of that. And we can look at history to see exactly where we're heading with this. I mean, you look again. I've done other videos on it. You look at 1933, 1934 Germany. You'll see a lot of things in that are familiar to what's happening now. All right, so I appreciate you watching, and stay tuned. Like I said, the Walker case is going to come up March 8th, I think it is, but I'll be posting about it on the website at thecivilrightslawyer.com. And I also have other cases that are in the works. There's something big happening with that family court judge search case. And there's going to be news coming up very soon on one of the other search cases that people have been following. So stay tuned, and you'll see something big drop here quickly. And hopefully I'll get some time to get some other videos done. Also the Barber case, the outlaw Barber case, we're getting going on that one as well. So too many civil rights violations, too many tyrants, not enough time. So remember that freedom is scary, and you have to arm yourselves with knowledge of the law. And that's going to be increasingly important. So remember, follow the guidelines, and I'll see you next time.